Everyone who knows everything about law. Mine is very limited, but they'll explain to us. And I start with the lady, since we're gentlemen. Amina, what do you make of the ruling of the Court of Appeal?
First of all, I think we have to appreciate the swiftness within which it was delivered by the Court of Appeal. I think that was well done, and we have to give it to the Court of Appeal. It gave it the importance that it required and within the time limit. So first of all, we need to appreciate the Court of Appeal for its timely judgment. Secondly, I don't know what to say, because if you look at it, NASA have not decided whether or not they'll go to the Supreme Court. We can say it is a good judgment for the people of Kenya and for IEBC, because now they can go ahead and print the presidential ballot papers. So in that regard, for them, it is a win.
But what kind of an impact does it have on the judiciary? How could the High Court get it so wrong to begin with?
You see, Trevor, we have a structure of court for a reason. Judges cannot be right always. Sometimes they have to get it wrong, depending on the facts and the law that is placed before them. Okay. So for this time, we cannot say actually they got it wrong completely. It's just that the issue of direct tendering was not well addressed by the High Court judges, but it's a good judgment.
All right.
Yes.
Apollo, what do you make of it?
Political judgment.
Okay.
Political.
Why is that?
Why I say so is because of two issues.
Yeah.
Now, there were, and these are two critical matters that the judges referred to. The issue of public participation and the question of direct procurement vis-a-vis that. Now, public participation is a constitutional issue. If it's a constitutional issue, then it's of public interest. The whole constitution as it is, as one document, is a public interest document. Now, you cannot, and I didn't understand that reasoning very well, that you can say that yes, public participation is constitutional, but it does not apply when it comes to constitutional imperative with regard to procurement. That argument
was that the argument really? The argument was that it does not apply when it comes to direct procurement.
And that's what I'm saying.
Yeah.
Direct procurement is constitutional itself. It's not unconstitutional. But then you are saying that one part of the constitution, okay, which is public participation, there is no argument that that's a constitutional issue. Yeah. Does not apply to other facets of behavior of a state organ. That is the argument that did not come out very well. Another issue that I have a problem with the judgment, I entirely agree with the judgment, but I'm just flagging out the reasonings. Now, the judges also intimated that you cannot penalize an institution that lacked time to do a particular procurement, competitive procurement, because they lacked time because it was engaged in litigation. Remember they said that. Now what the judges did not talk about is that they engaged in litigation because they had violated the law earlier. And the High Court had actually flagged out that, and it's not contested. And again, the Public Procurement Review Board also flagged out when they flouted the law. And they flouted the law when they used first wrong forms for restricted tendering. They used open tender forms. So they were in litigation because of the misdemeanor of the same state organ, and that's why they lost time. So those are the only two issues I can flag out from that
Even
judgment.
though there's a reasoning as to why they lost time, whether it was wrong or right, the bottom line at this particular point is time is actually running out.
Yes.
So at what point does the good of the public override the rule of law?
Yeah, that's a very good question. That's a very good question.
Yeah, and I'll come to you.
That's a very good question. The question of time vis-a-vis public interest. I've said the Constitution itself is public interest document. So you cannot violate certain aspects of the Constitution and then rush back to this argument of public interest, because public interest is actually the constitutional document. So whether time is short or not, so long as it does not fit the Constitution, then it is not public interest.
So do you agree with this judgment or not?
I agree with the judgment, and we need to go forward.
Okay.
It's only the reasonings that do not make sense. And I've flagged out those two issues. The issues of that they lost time because they were involved in litigation, and also that with regard to public participation, it is not required under direct procurement.
Okay, Amina?
For me, first of all, I'll say that public interest cannot lie in breach of law. It has to lie within the law.
Yeah.
But in this circumstance, the CEO of IEBC, in an affidavit, explained to the court that within the time limits that they had, within the time that they had to work in, it was impossible to procure open tendering and public participation. And that is why we have the provision of direct tendering. And in Section 2 of the Public Procurement and Asset Disposal Act clearly states that you can opt for direct procuring if it is impractical to go to open tendering, which is what they resorted to. And I think it is proper because Section 104 and 105 of the same Act gives the criteria for direct tendering. And public participation is not among them. You see, if you say within the time limit they would have gone for open tendering, then it beats the whole logic of going for for direct tendering, because then you're denying Kenyans the opportunity to participate or competitive participation. It does not mean that direct tendering actually is not fair, competitive, or constitutional. It is fair, competitive, constitutional, but it is to be used in circumstances where open tendering is impractical. And in the requirements that are clearly set out in the Act, public participation is one of the things that is put out.
So what kind of an impact does this have on the judiciary? Because this kind of ruling is coming after the president and the deputy president, many say, threatened the judiciary. And then there's a favorable ruling.
First of all, for me, I think the judiciary should be beyond reproach. The judges, I come from a school of thought where I look at the judges to be moral, more moral than even Caesar's wife. And so for me, it's really hard to impugn bias or to impugn bias on the judges. But then again, if you're going to say the judiciary is biased, we can say the NASA won during the High Court ruling and IBC won during the Court of Appeal. But look at it again, no one is winning. It's the judiciary is just coming out to present a ruling based on facts and law. And they have clearly couched their determination on facts and law, and they have clearly set out the law. So if you're going to criticize the judgment or the judiciary, go for the merits. Go for the judgment. If you want to appeal, appeal, but do not attack the judiciary directly.
Apollo, do you reckon those utterances had an impact?
No, it's difficult to actually take that position that they had an impact. In fact, I know certain political players went personal against the High Court judges. Yeah. And I have to thank the NASA Brigade, because after this ruling, we've not had them impugning that so-and-so is a relative to so-and-so, the way the Jubilee wing did with the High Court judges. So basically, for me, what I'm seeing is that the judiciary veers very close to politics in certain instances, but sometimes also gives judgments that can baffle and unravel the whole constitutional concept that we have, especially on public participation. This public participation, and nobody actually is opposed to direct procurement because it's constitutional. That's not the issue. The issue was that once you make a decision that you want to go direct procurement, is it important to then involve the public and inform the public that we want to go direct procurement, and these are the reasons. And that was the public participation that NASA was actually bringing out. Of course, the judges went to the narrow path and said in direct procurement, there is no requirement for public participation. Yeah. But public participation is constitutional, okay? Even if you invite public interest, it cannot defeat the constitutional document. And there is where the argument is a bit hollow for me. Yeah.
Okay. Now, we were talking about public interest. How do you even balance that per se? Because if you say that this is based on public interest, how do you know how many people are for or against it?
Yes.
Because now that is the other thing the judiciary was using.
Yes, and that's the thing. The thing is that once you're talking about public interest and you juxtapose it with the Constitution, okay, the Constitution takes precedent. The public interest as a concept cannot be invited to come and defeat a constitutional provision. Basically, that's it. Whatever argument you want to bring out on public interest, it must be within the four corners of the constitutional provisions. Okay. So you cannot bring in that concept just to defeat a constitutional provision.
Okay, both of you are very well versed with the law. So can someone deduce that the 5-judge bench had more wisdom than the 3-judge bench?
Well, you cannot say they had more wisdom. All judges are clothed with sufficient wisdom. But I think because it's a superior court to the High Court, and we can say they looked at the matter with fresh eyes. They looked at the issues again with the law, and they determined it with the facts that were provided to them by then. They had, well, 5 of them is better than 3, you can say, because they will discuss the matters broadly. And I think when you come to the issue of public interest, and as the senior has here stated, you see, I think what persuaded the court was the time limits, and that is why they came out and said, you know, public interest also has to consider the Constitution, as senior goes to state. You see, the August 8th election cannot be changed. Yeah. It is engraved in our Constitution. If you want to change it, you have to call for a referendum. Okay. See, in considering the time limits that IEBC had, it was only within public interest that they make the determination that they did. And I think the public interest aspect of this case narrows down to the time limits of IEBC.
Apollo, do you agree with that? Because I know you've been really against this issue of IEBC running out of time.
Yes. Yeah. You see, public interest was used by the court, okay, as the shield, so that they can make a political pronouncement in the decision. That's the thing.
So if it's a political pronouncement, then does that affect the independence of the judiciary? Then?
No. Public interest cannot defeat a constitutional provision. Whatever argument you want to bring, and you can argue public interest from whatever angle. Yeah. But that public interest must yield to the constitutional provision. And that is the issue. On whether the 5th bench of the Court of Appeal was more wise than that, I think the Court of Appeal agreed with the High Court substantively in almost every issue. Okay? It is only that the decision is what they didn't agree. For example, they agreed on the issue of tabling newspaper cuttings. Okay? They adopted the same reasoning as the High Court, that newspaper cutting cannot be used with, if the author is not in court to adduce that evidence, then it's a very weak evidence. Okay? But you can see why NASA brought up that. They had to throw everything that they had in the case because they don't have the register of people who enter State House and leave State House. So that you can give, because that's another way of proving that these people of Ghurair actually visited the State House. It was almost very difficult to prove that. So they had to throw everything that they had, despite that some of the issues that they raised. And I agree with that reasoning. Yeah. That newspaper cutting is a very weak evidence that cannot be used unless it is corroborated by the person who made that statement.
Okay.
Yes.
But then again, at the same time, people argue that if they were allowed to print the others, governors, senator, MPs, and all that, so why was it so difficult just to print the presidential? Why do we agree that are we saying the others are of a lesser value? No.
And again, the Supreme Court, the Court of Appeal brought up that issue of the divisibility of that contract. Yeah. And they actually threw away that argument of IEBC that this was one contract. They said that a contract, you must look at the provision of the contract, on whether the contract is severable that you can perform one part of it and not perform the other part. And you cannot say that a contract just from because the contract itself was not the subject of litigation itself. So we didn't have the benefit of knowing each provisions. But the argument that you cannot divide portions of a contract was also a very weak argument that the judges actually observed and threw away. So the question you've asked, if they are printing other ballots, why is it not that they can't print these other ones? Now, the question is this. This is a political contest, mark you. Once this political contestation and issues have been raised with regard to the players who are in that political contestation, and if it affects the printing of that ballot, because this is an election we're talking about, then you cannot just wish away everything. We've not had political contestation with regard to the other ballots. But here is where an allegation was made that one of the players in that political contestation actually met the printers. That is why it makes this particular aspect of the presidential ballot an easier issue to deal with vis-a-vis the others.
Okay. Following this ruling, let's listen into what Ezra Chiloba had to say. He's the CEO of IEC, was speaking to Mark Masai yesterday on NTV tonight. Let's listen to his reaction to the ruling.
It's really for the Kenyan people. If you look at it, there was a lot of anxiety in the political spaces in terms of how we're going to get the ballot papers home for purpose of presidential election. And I think the judgment affirms the position that we had taken earlier. And that is really on behalf of the people of Kenya, because that confirms that we now should proceed to get ready for the election, and particularly presidential election. And as far as the court decision is concerned, for us, we see as a green light to proceed to do what we're supposed to do. And remember that the first time we presented our case, we said the printing of the presidential ballot papers was supposed to commence on the 18th of this month. Now we are 2 days late, and that meant that immediately the decision was rendered. We had to get in touch with Dubai and issued instructions that they should proceed with the printing of the presidential ballot papers. So we expect that in the next few days, they will commence actually tonight.
Okay.
And throughout the weekend and the next few days, we should be able to conclude that particular process. So we might be late by 2 days, but we're still optimistic that this allows us to be able to recover on our plans.
Amina, the CEO says this was a ruling in favor of Kenyans, but as we've seen the political field, it's either NASA or a Jubilee win. As a first-time voter, what does that message portray to you? Are you more convinced now that we have IEBC is independent, or are you still a bit conflicted on who's pulling the strings where?
Well, for me, IEBC is, first of all, they're really trying. I can feel their struggle every day. They're being pulled from one direction to another. And for me, I think that we have failed to support this institution. We have failed in our in our duty as citizens of this country to support this institution. Now, given they have their own faults, they like also spending some time in court, as we have seen, litigating, wasting Kenyans' time, and not putting into consideration that the August 8th election is not going anywhere. It is waiting for them. That date is sacrosanct in our constitution. It is, you cannot change it at this time. And so for them to waste time, and I think they have done quite that much, wasted their own time, it's not fair to the Kenyan people. But in this regards of this judgment, the fact that we have now an opportunity to, and as he said, they were supposed to start printing the ballot paper printing for the presidential candidate on 18th. They are a few days late. It's hope that we are going to have these elections. You know, if we don't have these elections, you can imagine the constitutional crisis that we're going to have.
Yeah.
Yes. So I feel it is a win for the public, for the people, for the first timers like me who want to vote on come August 8th. Yeah. We should not reduce our democracy to opinions of political parties and to what political parties hold to be their daily interest and what they want to achieve on that day and time. If we cannot support our independent organization or IEBC in this case, let's just abide by the Constitution. Let's say we are going to have that August 8th election. Come rain, come sunshine.
All right. Apollo, do you reckon we have not been supporting our institutions?
No.
Especially the IEC.
No. I think litigation has actually supported them. You see, Trevor, we have, under the rule of law, if you have a dispute, you're supposed to take it to court.
Yeah.
And this one, I'm addressing the people who have been criticizing NASA for going to court. Do they want NASA to take a panga and go to IBC? No, you go to court. That's what the rule of law states. Okay, you have a dispute and you take it there for adjudication, and that is what they have been doing. Right now, we know that some of the litigation that has been taken out by NASA has gone a long way in strengthening or the work of that independent institution, or clarified certain aspects of the law. One of them is, where do you declare the question of presidential election? Okay, where do you announce it, and vis-a-vis where do you declare it? Now we know it can be announced at the constituency.
Yeah.
Okay, that litigation was very helpful to clarify that issue.
Yeah.
Now, there's another litigation, and the ruling, I think, is going to come out today. The law talks about that in case there's a failure of the system, the Kenya Electronic Management System, then IEBC will put in place a complementary system.
Yeah.
Now, that complementary system has never been known what it is. Now, you have to litigate it so that we know, everybody understands what is this complementary system. Now, that ruling, I think, is being read today.
Yeah.
So litigation goes a long way in strengthening these institutions, because sometimes you find that the law is not clear and people are just demanding clarity so that everybody is on the same page.
But the counter argument to that is that NASA may have also been bringing up barriers that eventually will derail the entire process. For example, the latest now is the inclusion of police officers, about 42 of them, at least that the NASA presidential candidate gave.
Yes.
And the police confirmed that they have those people, however, they're not supposed to be clerks.
Yes.
But even then, IEBC CEO Ezra Chiloba also addressed that same issue. Let's listen to what he had to say.
Yeah.
How we structured our planning around election. Other than, war, election is the other event that addresses a lot of logistics and human resource. And in our case, we target to use over 370,000 election officials. These are Kenyans from all walks of life. And for presiding officers, those are recruited from the places they come from. And so far, we've been able to recruit them. We have about 362,000 already recruited. They're getting latest. But most importantly, this list to be public for all stakeholders to be able to vet the list of officials who are working with the IBC in this particular election. So when it comes to the role of security officials, it's also well defined. If you remember, early this year, we were able to launch what we call the Election Security Program, which now defines the framework of the relationship between IBC and the security agencies. And ours was to build their capacity on how to provide electoral security on the election day. And that's a program that has been going on. And we expect that the last person to be trained will be the 182 or second thousand officer from the security forces. So we have a clear program that is well out there.
Apollo, doesn't that justify what Amina was saying earlier on? Throwing stones at the institution that has not even been tested yet. This is going to be their first one.
Okay.
Yeah.
Now, you can see Chiloba is also admitting that even these names needs to be public, so that people know. Now, whenever there's an issue and in a political contest where somebody alleges certain things and it's been admitted that that list is authentic, it is now behoves the electoral management body then to clarify. And you can see those clarifications are coming out. Most of these issues that are raised by either side in a political contest just requires clarifications. And you can see those clarifications are now forthcoming. Yeah.
But I think we forget that independence of a body like IEBC also depends on perception of the public. If we keep throwing stones at IEBC and bringing allegations that are not substantiated, counsel. You know that he who alleges must prove. These political parties should not be coming out every day with a new allegation, throwing stones at IEBC and have no sufficient evidence to prove. Yes, I appreciate that IEBC has been forthcoming, with the information. This is not it, this is it. But if you keep dragging the name of this IEBC in our streets, in your political arenas, the perception that you're creating in Kenyan minds is that this organization is not doing well. This body is struggling in delivering in their mandate. So why would Kenyans then go ahead and trust that same institution? Good. Perception is very important in public eyes. If we condemn IEBC in the public courts, we are doing an injustice to ourselves.
With regard to that list, nobody has denied that that list was fake. They have actually confirmed that that list is okay. But now the clarification that is coming out is that they are going to be used for, they're not going to be poll officers. Yes, they're going to be, but nobody has doubted that list. And in fact, the police has confirmed that that list is authentic. And let me tell you, it's not only on IEBC. Let me give you an example, that the one that has also brought a lot of problems, and probably you guys also aired it. We have the acting CS for Interior. Okay? He's in charge of security. Yes, that is his docket. But also, he was appointed as the Jubilee point person in Nyamira. Okay? And it's also been documented how some CSS have been campaigning, okay, in contravention of the Election Offences Act 2016. Now, can you see the conflict of interest there? He's in charge of security, okay, but he's also campaigning, point person in Kisii, okay? And when such an issue is raised, you cannot say that people are throwing stones at the institution. People are actually flagging out issues that needs to be addressed and where conflicts of interest are arising. He's the one who is going to deploy all this security, but also is campaigning and is a cabinet secretary.
But that does not mean it's going to necessarily influence the guys who is deploying, because that is...
I mean, as we have all said, it's perception. It's perception, you see.
So, but what options does NASA have now going forward after this ruling?
After this, NASA has to campaign and wait for August 8th.
Can they appeal again?
Yes.
Of course, they can appeal. But me, as a legal professional, I would not advise them to appeal.
And why is that?
Because, first of all, the time that is there, they need to focus now on the campaign, and they need to focus on the issue of ensuring that there is no votes that are stolen. That is where the focus should be. It's not on the issue of ballot. Let the ballots come, but then ensure that the ballots are cast as per the law required, and they are safeguarded, and the results that come out are credible, verifiable.
Okay. Malyun, what do you make of it? Options for NASA now?
Yes, I will agree this time around. They should not waste time in our courts. I think our courts have done their part. The judiciary has done its part. It's time to play politics. Go, ask for votes. Stop with all this litigation. I'm not saying litigation is bad. Actually, it has grown our jurisprudence very well. It is an art. It's good for a system. However, I think with the time limits that we have, surely let's all move on. I want to vote come August 8th.
All right, and I want to bring in Ezra Chiloba again as well. He spoke of several issues that came out from yesterday. But for now, the other question is if NASA can actually prove in the event that Ghurair had already started printing these papers, because they were supposed to start on the 18th. If they can prove that they had already started before the ruling, does that make a case?
Let me tell you, Trevor, you know, people have made this printing issue to be something, a rocket science. Here at Nation Media House, starts printing newspapers in the evening. And I think they print more than around 3 million papers. And in the morning when we wake up, we find those newspapers in every corner of this country. Okay? And that is less than 12 hours they're printed. There is enough time for printing. That's what I'm trying to say. Yes. And even if they don't print on 18th, they could still print it within a week. Because as I've demonstrated to you, Nation Media newspaper print from in the evening, and they print 3 million, and it is transported apart from printing. In the morning I wake up and you find it in every corner of this country. This printing issue is just not a big deal, the way we are trying to make it.